NTA Blog. Tens of millions of taxpayers may be eligible for significant tax refunds if they act by July 10, Part 1. Tens of millions of taxpayers may be eligible for significant refunds related to penalties and interest assessed during the COVID-19 disaster period, but most will only receive that relief if they take action by July 10, 2026. This issue stems from a recent court decision, Kwong v. United States, which interpreted the tax code to mean that filing and payment deadlines were automatically postponed for the entire COVID-19 disaster period, from January 20, 2020, through July 10, 2023. If that interpretation ultimately holds, many penalties and interest charges assessed during that time may have been improper. What does this mean for taxpayers? You may be entitled to refunds or abatements of penalties for late filing, late payment, or missed estimated tax payments. You may also be entitled to adjustments of interest that should not have accrued during that period. But here's the challenge: this relief is not automatic. In most cases, taxpayers must file a claim, generally using Form 843, by July 10, 2026, to preserve their rights. Because the law is still being litigated, many taxpayers should consider filing a protective claim now, even if the final outcome is uncertain. This situation raises serious concerns about fairness. Taxpayers who are informed or have professional representation are far more likely to benefit. Those who are unaware, especially low and moderate income taxpayers, risk losing refunds they are legally entitled to. That undermines key taxpayer rights, including the right to be informed, the right to pay no more than the correct amount of tax, and the right to a fair and just tax system. There are also practical barriers. Claims must currently be filed on paper, making the process slower, harder to track, and more burdensome for both taxpayers and the IRS. The IRS and Treasury should act now to address these issues. That includes raising awareness, considering deadline extensions, exploring automatic relief, and enabling electronic filing of claims. The bottom line is simple: this is a major opportunity for taxpayers, but only if they know about it and act in time. Without action, we risk a system where the well-advised benefit, while the unaware are left behind.
The audio version of the NTA blog is created using AI for conciseness and a computer-generated voice. Although reviewed by a human, inconsistencies in context, pronunciation, and tone may occur. The views expressed in this blog are solely those of the National Taxpayer Advocate. The National Taxpayer Advocate presents an independent taxpayer perspective that does not necessarily reflect the position of the IRS, the Treasury Department, or the Office of Management and Budget. NTA blog posts are generally not updated after publication. Posts are accurate as of the original publication date.